We have massive breaking news out of the United States Supreme Court today. This is a huge deal, absolutely historic. The U.S. Supreme Court has finally decided to hear a case about 18 U.S.C. 922 G3. This is the statute that prohibits someone who unlawfully uses a substance from possessing a firearm. Not possessing it while they're currently intoxicated, but someone who, let's say, smokes marijuana or has smoked marijuana from possessing a firearm at all. This is a huge deal. I know I'm like getting really excited about it, but it is actually a massive deal to progressing our Second Amendment rights. I'm going to talk all about it. I really think you're going to enjoy this one, so let's get into it. Before I do that though, if you are new here, please do subscribe down below if you're new. Really appreciate it. And yeah, let's get into it. Okay, so the case is known as U.S. versus Hamani. Again, this is a really big deal, and if you are a Second Amendment supporter, you should know about this. This is massive. Okay, so the case is known as U.S. versus Hamani. It was first brought in the Eastern District of Texas, and basically Hamani was indicted by a grand jury because he used a unlawful substance and possessed a firearm. Again, these aren't things that have to happen concurrently. You can be someone who uses or abuses unlawful substances, which, by the way, there's a lot of things which don't cause you to be dangerous or violent that are unlawful substances. A key one, as an example, is marijuana. Anyway, he used an unlawful substance and possessed a firearm, and he was indicted by a grand jury for this. The Fifth Circuit of Appeals threw it out on Second Amendment grounds, and now the Supreme Court has decided to hear it. I'm going to talk about first why this is so big, and then I'm talking about what people are saying might happen. Again, I'm not on the Supreme Court. I'm not in those meetings, but I think we can get a pretty good read on what might happen and what might come out of this. Okay, first things first. Let's talk about why this is so important. Okay, so we honor the text of the Second Amendment. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. That's pretty clear, but people are always trying to restrict it. And one of the key ways they've tried to restrict it is by chipping away at all the things that sound reasonable, right? Red flag laws sound reasonable, but in reality, it's a violation of due process. Another one is this. There is no good argument I can think of, right? I'm not a marijuana user, and I probably will never be a marijuana user. But there is no good reason I can think of why someone who, let's say, smokes pot once a week should be prohibited from having a firearm ever. Right? Again, I want to be clear. It's not having a firearm while intoxicated. It's someone who is a habitual marijuana user from owning a firearm. So like I could be completely sober, and if I use weed once a week, let's say, and I have a firearm, that is a felony, right? And I can't think of a single good reason why this would be. Think about this logically, just for like 2 seconds. First of all, marijuana is not a drug which makes people more violent, right? Most drugs actually aren't drugs that make people more violent. Certainly not when you're off of them, right? Like, it would be one thing if you say, okay, I'm intoxicated, I can't have a firearm, right? That's obviously black letter law. That's fine. That makes sense. I agree. If you're intoxicated and you're not currently able to process what's going on, you shouldn't be able to drive. You shouldn't be able to have a firearm, right? That's just the reality. If I'm literally physically right now, high on PCP, I probably shouldn't be able to have a gun. Fine. I'm a big Second Amendment supporter. My shirt says Second Amendment. And I agree with that, right? That's reasonable. That's black letter law. No problem with that. The problem is, in what world does smoking pot once a week make it a danger more than anyone else for you to have a firearm? It doesn't make any sense. This is what I call kind of the reasonable phrasing encroachment of our Second Amendment rights. I mentioned earlier, right, about the red flag laws. And I think that's a classic example. You say red flag laws. This person's, violent. They shouldn't have a gun. Okay, I agree. If they're violent and they've been adjudicated by a court to be violent, then they shouldn't have a firearm. As long as they have a right to face their accuser and they've had due process. That's the key problem with the red flag laws, and that's the key problem here too. If you say, okay, this guy is just drunk all the time, right? He's always drunk. He's a violent guy. Well, guess what? We already have systems for that. We already have systems to stop people who are in that category from possessing firearms. And that's what the U.S. Supreme Court is tackling right now. The key point behind language like this is anti-gunners trying to make as many people as possible not be able to carry in as many places as possible. It's the same reason for sensitive places. The reason they want to make, like, say, the president escort not be able to have a gun within, let's say, 1,000 miles is maybe you're driving along and the president comes by and you have to pull over. Boom, you're a felon, right? It's the same reason you can't. They want to draw radiuses around school zones. Because if you draw a 1,000-yard radius around a school zone, well, my apartment is literally, the way I drive to my apartment, right over there is a school zone. So I can't have my gun in my car and drive by there? No, it makes no sense. But it sounds reasonable, right? To many people, they say, oh, okay, well, schools shouldn't have guns. We had guns in schools at the time of the founding, actually. Students brought their gun to schools at the time of the founding. Thomas Jefferson was one of them. But you can kind of load in the gun control there. And now, maybe it's not possible for me to have a gun anymore. Boom, I'm unarmed, right? That's the same point for this. Think about it like this. There's many Americans, many college students, let's say, that have taken Adderall before, as an example, off prescription. Is that a good thing to do? No, I'm not advocating for it, but that's just the reality. People have done that. And those people are ineligible under the letter of the law from possessing firearms. The first instance of this kind of regulation was the Gun Control Act of 1968. And that was basically the start of all this type of legislation. So there's no historical tradition for this, right? So it doesn't pass the historical tradition test. But the government in the past has argued that people who, let's say use weed once a week or use unlawful substances are at a higher rate of gun misuse. And that probably is true, right? Just statistically, that's probably true, because if you look at even if it were to be distributed totally normally, right? Even just the dealers would push that average up. So that's probably true. But the truth is, you can't deprive someone just because they're slightly more likely to misuse a firearm. If we did that, we could draw it along very lines that people don't want to draw it along, right? That could get us to a slippery slope real quick. Like, for instance, men are more likely to reuse firearms. Should we block men from having guns? No. That would be ridiculous, right? No. Come on. And who draws that line, right? Who draws that line? What's the percentage where we say, okay, this group is 2% more likely to use a firearm? Okay, that's fine. What about 15%? Is that okay? No, come on. This is ridiculous. It clearly infringes on the Second Amendment. There's no doubt about that. I think I made it pretty clear where I stand. I think the U.S. Supreme Court should affirm that this is unconstitutional, because I think it clearly is. But what will the Supreme Court actually do? Like, what's actually likely to happen here? I am a little bit fearful. I know the Four Box Diner just released a video on this, and I'm very interested to watch it, right? I don't know if you guys know the Four Box Diner, right? He's a member of the U.S. Supreme Court bar. He's got a lot of inside intel. But I'm a little wary. The reason is, if you look at the Clarence Thomases of the world, the Alitos of the world, the Roberts of the world, and of course the liberal justices, they're going to rule against this in my view, honestly. But that's not necessarily lost, right? That's not necessarily a lost case. The reason is, a lot of these justices, by virtue of having been judges and attorneys in past life, are very law and order people. And they view it as almost obvious that someone who is breaking the law shouldn't be able to have a gun. And I kind of see where they're coming from a psychological perspective. Obviously, I don't agree with it, but I kind of see where they're coming from. The other problem with this case in particular is the guy has a really bad fact pattern. As people say, bad cases make bad law, and that's probably true here. I think in a traffic stop this guy had over the U.S.-Mexico border, they found text messages on his phone saying he was part of like an Iranian militia, something like that. And so this is honestly not the kind of guy that you really want to be having a gun. And we've seen this in Rahimi too, right? If you remember back to Rahimi, that case was basically lost because the guy was kind of a dirtbag, right? He was essentially a domestic abuser, allegedly. I don't want to get in any legal trouble, but he was essentially a domestic abuser. Actually, he might have been actually ruled to be one, but he was a bad guy basically from all conventional understandings, and that has led to bad precedent. And I am worried that this will happen in this case too. Again, I'm a realist. I hope it doesn't happen. I hope we get a really great decision, but it might happen. If you remember Rahimi though, that was still a Second Amendment win. And that's because the decision isn't just yes or no, white or black. They have to write a whole big document, right? That's actually what the decision is, right? It's a whole big document outlining how to handle these cases in the future. And I think in this case, Hamani himself, I think his name is Ali Hamani. Ali Hamani himself might lose the case. I would imagine he will lose the case. But I think we could get a really, really good two-way precedent out of that. Probably what needs to happen is we need to say, okay, if you are a someone who has in the past or has been adjudicated to unlawfully misuse drugs, right? That could be Adderall. That could be like prescription, like obviously prescription painkillers. That could be like your mom's like headache medicine, right? Like just that falls under the letter of the statute, right? If you are one of those people, we should say, first of all, does the drug make you more significantly more likely to be more violent? Okay, in that case, you certainly can't possess the gun while having it. I can't argue with that, right? If there's a drug that makes you, fall into a violent rage, you shouldn't be able to have a gun in your pocket while you do that. Fine, no argument for me there. And the second thing there should be other aggravating factors. So like in this guy's case, if you're part of an Iranian militia, you probably shouldn't be able to have a gun in the United States. Actually, you probably shouldn't be in the United States, to be honest, but this guy is, and so that's a whole separate issue. And so I think we may end up with a test like that. And if we do, that is a resounding 2A win. Resounding 2A win. So I think all hope's not lost. I think we will probably lose this case. And I think a lot of the 2A people, myself included, won't be that happy with that fact, right? That's just the reality, and that's something we have to live with. But I think it may give birth to a great 2A decision, a bit like Rahimi did, where, sure, we lost it, but the decision itself strengthens cases in the future. Remember, what we're trying to do essentially in the 2A movement is just build bricks. We want to build a wall in the end. And if we, maybe we don't put the best brick in there. Maybe we don't build a whole wall in one day. but just adding little things that stop, relatively minor encroachments. Obviously, there's no such thing as a minor encroachment, but relatively minor encroachment. I mean, this is not an AR-15 ban, as an example, on our Second Amendment rights. Adding these bricks to prevent that is an undeniably good thing. So I imagine that's probably where we'll end up. It's not what I would hope for. It's not the best case scenario. Certainly not. But I really, really do hope that that's what we get. Anyway, hope you did enjoy the video, though. If you did, please do subscribe down below if you're new. Really, really hope you enjoyed, and I'll see you in the next one.